Hi, everyone. Okay, this is Amelia. We are back. I am back with Lotus Justice. We got cut off.
Right when we were telling you the good stuff.
Yeah, right when we were getting to the good stuff. So we were talking about the children's court corruption, the child trafficking.
Right, but I was specifically I was talking about the specific language of the Rooker-Feldman Doctrine and how they cannot apply it to child custody cases, and I wanted everyone to understand this. Because no child custody case should ever have the Rooker-Feldman Doctrine applied to it. Because the Supreme Court tailored a very narrow application of the Rooker-Feldman Doctrine, and it pertains to state court losers complaining of injuries. Complaining means you file a complaint, okay? Now, this is legalese at this point in time, but a complaint is a trespass, something that can be solved with a monetary, pecuniary resolution, payback. You damaged my car, pay for my deductible and loss of use of car, blah, blah, blah. If you injured me, that's another issue. But the car can be fixed with money. See, it's a thing. So when you go, they're complaining of injuries. That means you're asking for money as compensation. When parents are appealing their child custody cases, they're not complaining of something that they didn't get paid for. They are claiming that they have been denied due process, their child was stolen, that a crime was committed against them. Complaining of injuries is not the same thing as claiming a crime, okay? Those are two totally different applications in law. One is a trespass, one is a tort. It is a torture to steal someone's child, period. It's a torture to the child to be kidnapped from his family and placed in restraint, which by the definition of that, placed into prison. The definition of prison is when one is being, against their will, held somewhere against their will, in the custody of authority. A child is in prison by the very definition of the term prison. So the child was arrested, stolen, and put into prison of CPS system. That's the way the law sees it. Okay. And that is a torture. And it was reported to the mother that he was so tortured he refused to sleep in a bed and slept on the couch waiting to be taken home for his mom to come get him for over 6 months. Or anyone in his family to come get him. Because like I said, he knew 50, 60, 70 people, right? And he thought, surely some of them will come get me. So these are tortures. You can't apply the Rooker-Feldman Doctrine to tortures. And not only that, but it reflects back on the fact that it does have a trespass value to it. Because pursuant to Title 27, not Title, 27 Code of Federal Regulations, Chapter 1, 72.11. So 72.11 of 27 CFR defines commercial crimes. And don't you know, which means a criminal offense in the federal construct. Offenses against the revenue laws, they're very specific, they cite them. And these are considered crimes by federal or state commercial crimes. Offenses against the revenue laws, burglary, counterfeiting, perjury, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame. I love that one. And like offenses, extortion, swindling, confidence games, and attempts to commit, conspire to commit, or compounding any of the foregoing crimes.
So I explained in the previous episode where we got cut off that the American Safe Families Act, effectively, which was passed by the Clinton administration in 1997, it put a $10,000 bonus on every child's head. But not only that, what people don't understand is since the inception of this American Safe Families Act, that every year, in order for the state to be in compliance, they have to increase the amount of children that are removed to meet the quotas. The state
and we
quota.
discussed, and we just discussed in the previous segment of this day that they are self-reporting and self-regulated. There is zero federal oversight. They are not doing federal inspections or audits or compliance. It is 100%. And the point person in every state, Ohio or State Department of Job and Family Services main agency, the liaison is to a special attorney with the Supreme Court of the state. So the Supreme Courts of the states are the in-charge administrative banks to all this child trafficking. So, and you got to remember,
we also have the ICMP that was founded prior to the American Safe Families Act, which is the International Commission on Missing Persons, which is owned by Bill Clinton himself. And then after the American Safe Families Act was passed, Hillary Clinton lobbied for the right to lie, which is a social worker's right to lie. So they can lie. They don't give due processes in the children's court. Routinely, public defenders and the prosecutors are withholding evidence, and the clerk's office is denying parents the right.
These are not trials. These are hearings outside of the law in all respects, that they are getting paid to admit whatever the product of those hearings are. They're getting paid per head of what they acquire in those hearings. I mean, this is just outright disgusting racketeering. And remember, kidnapping and larceny are commercial crimes. So here's the point: if they apply the Rooker-Feldman doctrine and say, "Oh, you're complaining of injuries," like, no, I'm actually telling you I had crimes committed against me because my constitutional rights were violated. And in that, the minute you say that, you have just declared that the government agencies are actually committing commercial crimes of larceny and kidnapping and racketeering, and that any individual who works under the color of law, okay, who attempts to conspire to commit or compound the kidnap and compound the larceny. So if on appeal you go to the next court and they deny you due process again, that court has compounded the criminality and they are guilty of kidnapping and larceny. And these are all crimes under the larceny laws and the kidnapping laws, but when they're attempting as state agencies to hide the unlawful taking of children, which then, if you can prove that the local attorneys have conspired criminally to seize a child unlawfully, way outside the law, and it's prima facie, which is what we have in this case, and the courts up into 2 federal, state, territorial levels have applied the Rooker-Feldman doctrine because we have exposed a commercial crime being committed in its glory in a county courts in one county in the state of Ohio, and how it was has been perpetuated, and they have obstructed justice in like 13 cases we filed.
You presented this to the courts, and you filed. We have filed. We are literally going through their administrative process with proper fashion and argument and the proper standing of law. And everywhere we go, these people compound the kidnapping and the larceny and all of the crimes in this case. In this case, they put the mother in it. She went to what's called a judicial hearing. They promised the mother, "Hey, here's the deal. We were going to give you just community outreach, is where you go to like a drug treatment program, which would have been what she should have gotten, even with what she was charged. Even if she pled guilty, it wasn't a prison-related offense. Okay, She should have, first-time offender, she should have gone to a drug treatment program for 6 months. Her attorney, apparently they offered that to her, and her attorney turned it down without asking her. Okay, first off, she was like, "I wanted drug treatment." She goes, "Why did you refuse that?" He goes, "Well, you'll get a better deal. You should just get this." He comes back. They punished her for his stuff. Say, "Well, now you're going to go to prison for 6 months and do 6 months in drug rehab." So this is how her help with attorneys starts. And then this guy is the same attorney for her son. So they started that way and said, "Well, here's the deal. It's simple. Just plead guilty, and we'll return your son," because no one knew where her son was. He was stolen. He was left on the side of the road by the cops. At this point in time do we have proof of life of Clay? Does anybody know?
No, we do not. And this is the most scary part in this case. I have recently found out that the county clerk has closed her appeals. They're just closed. They're showing closed. These people...
So they just closed them all down. On what grounds?
They're all closed. I have no idea. They're still on appeal. One's in the circuit court, and the other one's getting ready to go circuit and probably the Supreme. I mean, these are on appeal. These people are criminals. And they think because there's so many of them that hold the bar union line, and to be honest with you, most of it is they're just stupid in the law. And they're not required to know the law.
I used to think that too, that it was just incompetence, but then they
started a lot of it is.
Incompetence.
It's planned incompetence.
Sometimes it is because they intentionally keep some of the workers compartmentalized, so they don't know, and they're specifically assigned certain tasks.
And as my old friend Bill Elwood, we haven't seen in a while, don't know where he's living or whatever, but used to say, you have to be able to read to see what you're saying. Like, he even professed that they don't even, like, they read my writings, which some of them, are complicated and convoluted, and they are high-minded, but they don't even understand basic law. They don't even understand their own administrative code, and that stuff's easy for me. Process is easy. If it's written down, and, I have a chemist background, and you go to analytical standard test methods, and you go, I didn't know how to run half the equipment I did as a chemist, but the processes teach you, and they tell you the exact steps. Same as the law. There's steps to law. And these people violate even those steps that they published for their own administrative, agencies. But no one's ever tested the judiciary. The judiciary has not been tested to see if it's actually doing what it says it's doing in the statutes. For at least since Nixon, for sure, whenever they made it bar union. And
when we're a country that holds the Constitution as the supreme law of the land, how can we have an agency operating within the United States that has no constitutional oversight, has no oversight at all?
They've taken the constitutional oversight position out, which is the people. They took out the fourth branch of law. And they took out the fourth branch of law, to be honest with you, because white men were fixing juries. Okay? 12 white men were letting a white man beat a little black boy to death and get away with it because he looked at his wife wrong. And so they took the common law grand juries away because they were being abused in corrupt institutions of the counties. And so they took them away, but the corruption was also the inherent system, the mayor and the sheriff, the people, those 12 white men were all the members of the men were running little hooligan states and little towns and tyrannizing blacks and women and I'm talking about in the 1950s. It's a saved mentality of the men who were egregious plantation owners versus cooperatives. I mean, the difference between a plantation and a cooperative is that the guy who's running the guy who's running the plantation is mean and cruel, and the guy running the cooperative sees you as an equal partner in a collective and treats you right, and he's your business partner. He's the CEO of your corporation. See, they're in this duality, and so they took them away, and no one complained. The white men sure did, and they just incorporated it and ingrained the indoctrination and the crimes within it. But it's not just white men anymore, people. It's women and black men, and it's all just about the personal lucre anymore. And they compartmentalize us. They compartmentalize these people. But I write the law. I mean, I sit and go, hey, this is what your stuff says, and they're still denying that. So, but I'm trying to explain to people how it is illogical in law to apply the Rooker-Feldman doctrine to child custody cases, because you're not complaining of an injury. You're not asking for a monetary recompense for a trespass, which is what a complaint of an injury is. You are claiming a crime because parents are going in appeal and saying, the courts denied me. The courts actually broke the law. The court broke the law. Not this guy. this court openly broke the law. This guy broke the law. These people over here, the state broke the law. They're actually claiming, and when you claim the state itself, the agents of state are breaking the law. When it involves children, that makes it a claim of a commercial crime. The appeal of a parent from a custody case on constitutional grounds.
In one sentence, if a parent wanted to appeal and make the claim that their constitutional rights, in one sentence, how would they word that on their appeal?
Well, I'm saying that this is the argument. Sorry, this is the argument that needs to be had. That people need to understand that they need to learn to argue against. The Rooker-Feldman is the central hammer that's shutting down all these cases, and it's being egregiously misapplied because it's being abused to hide open criminality. Okay, but even still, what they're saying is, well, you, in order to, and this is what every parent must do now, in order to even possibly overcome the Rooker-Feldman doctrine, is the minute that your child is kidnapped from you by the CPS, state, or sheriff, you immediately file a writ of habeas corpus with the district court of the territory, immediately demanding the child's return. Because if you don't, because
the district court of that territory that you're located in,
you're living in, you find the minute the day that you immediately. In fact, I would suggest that parents have like a habeas form written up. We should probably, but because what the Rooker-Feldman doctrine says is it's about a legal term called res judicata, which means already judged, and these cases aren't judged. So there's only so many ways to say that these can't be reviewed. And what they're saying is that if you didn't come to the feds professing that a federal construct was involved and asking for our relief to the district courts, specifically the district courts, then if the state decision that comes forth, you lose, you can't come to us with a complaint. So basically, it's a surety policy. It's saying, hey, if you don't ask for our help before you get injured in trespass, we're just going to wash our hands of you. That's basically what the Rooker-Feldman doctrine says, that we're not going to even entertain to insure a claim against you, with you, because when you go to a court, you're buying bonds. You're saying, I'm going to pay $400, and you're going to derivatize this $10 million, because you're going to go write this bond and this bond and this bond. That's what they do. Mm-hmm. That's what they do. We're not going to insure your appeal if you don't ask us for help beforehand. That's what the Rooker-Feldman doctrine basically says. But it has to be, otherwise they have to take it, because you're getting the elite law people to buy into your argument. You're saying, hey, I think that this guy down here is a criminal. The argument of that requires to be suretized. In the Constitution, you used to have 20 silver pieces to bring a claim. Okay? You used to have a bond. Okay? Now, that would cover all claims up to even personal replevins, where you bonded yourself out of jail for the criminality. So it'd be like an insurance policy. Here's $20. I'm not a criminal. Okay? Mm-hmm. By the way, if you were doing a replevin, that would be $30. Funny, that's the value they put on Yeshua. Get it? So our founding fathers determined what surety we had to have to bond ourselves out of prison personally. Personal replevin, a flesh and blood replevin, is the same value you would pay in the standard common law if Jesus had bonded himself out. And that 30 silver pieces they put on his head. So the bounty of Jesus is the foundation for the 20 silver pieces in the Constitution. Okay? Because in a replevin you have to bond 1.5 times the value. So basically, pursuant to the Constitution, our Constitution values a man's argument, like Jesus was, at 20 silver pieces. Now, poor people they didn't have silver pieces. So if you wanted to bring a claim and you were poor, you would go to a statesman, a sovereign of the land, who was vested in things that were criminal and would not want criminality to be affected in his region. And he would say, okay, I'll buy the insurance policy. Because they bonded it. That's what the 20 silver pieces is for. So the courts, now you can go bond them You don't work in silver pieces. You work in hypothecation. You work in Federal Reserve fiat notes. That's why they're banks. They're negotiable instrument banks. They've been purely negotiable instrument banks under fiat hypothecation since the Nixon scare and the gold was taken, and he said there's not enough gold in the Federal Reserve to cover the Federal Reserve notes out. From that day forward, the courts had the capacity to affect bonds in hypothecation.
Okay, so to digress, I apologize, but to digress, so appeals court has just closed down your cases with no response or grounds.
None. No, we don't know why they're registered as closed at the clerk, and I noticed them that they were still open.
So
I said these are still uphill.
What is your next move?
Well, we're entertaining going to the Seventh Circuit in Indiana, because the guy in Indiana, it's like he hasn't read anything, and I love how they always say we don't have jurisdiction, but we've determined that you have no claim. Well, that's an exercise of jurisdiction. And that's the last point we can make about the Rooker-Feldman Doctrine. First off, the Rooker-Feldman Doctrine has to be argued. These judges can't just apply it. The state should have to aver it. Mm-hmm. Okay? I'm sorry. That means that that the state is always getting the benefit of a summary judgment whenever they're the plaintiff. Because on an appeal, you're making them the plaintiff. Prove that you didn't harm me in this, back up, right? Mm-hmm. Because there's a faith that going down, they're following the law, right? So it should be just fine. No one should ever have to sue the government. No one should ever be appealing any decision if they were doing their job, okay? So the fact that they barred you, that there's so many claims, that there's such egregious criminality, they had to close the bar down and control the arguments that are brought to it by especially in child custody cases, telling parents that they can't even file habeas for their own children. I'm sorry. Let me restate that, because parents apparently is the legal term of one, owns a ward. The mothers and fathers are being denied the capacity to file habeas for the children in Supreme Courts. They're just suspension of the law in general, and what we're seeing is a general suspension of the Constitution in states, and they are openly stealing and trafficking children from parents. And the appellate court, in the cases that I'm with where it's egregious, don't even act like they're reading the stuff.
No,
and all their parenting is Rooker-Feldman, and it doesn't even apply.
Denying parents the ability to file. They're saying you have to have an attorney. Well, these attorneys in children's court, private attorneys charge a minimum of $25,000.
That's okay. What does that tell you? Okay, what's that called when in criminal enterprises? That's called
extortion.
Gaming. That's called gaming.
Mm-hmm.
That's gaming. It's creating it's called criminal enterprise. They have created a market for themselves in the trafficking of your babies, where you pay one of their guys a whole lot of money to make sure that they don't kidnap your kid, which they already did. Oh, and if they did kidnap your kid and I happen to get him back, you can't sue them because you didn't go to the feds and ask them for your help first. So what I'm telling you is every parent who has a child that gets taken needs to immediately file. I don't care if it's on a notepad. A habeas corpus is a habeas corpus. Anybody can file a habeas corpus. It's $5. I think it's $15 in the district here. It's no more than $15. Okay, I think it's $5. And you say you want your kid back. Put an affidavit of facts and say they were taken against my will. You put it in there, because then it doesn't matter. You preserved your federal rights.
I have a template for the parents, which is an outline of the affidavit of facts. So if you need assistance, creating your affidavit of facts to get notarized.
And you could even say, I'm filing this habeas to notice you of that I am demanding assistance. Mm-hmm. And put it on them, because a habeas is like something they have to take. A habeas is you can go and buy the lowest insurance policy that you can buy at their court, their bank, cost you $5 of your own money. 5 fake fiat dollars. Okay? Less than a super meal at McDonald's. You can go down there and you can write in your own words as a parent, and you say mother and father, let's make that clear. Mother and father, asking for your babies back. However you do it, they were taken against your will and stolen, kidnapped, because the feds aren't listening. But for $5, you can go to the Fed District Court and say your child was kidnapped. And if you have preserved a criminal commercial claim in the federal court with that, and they can't use the Rooker-Feldman Doctrine on you because you have exercised what's called sub justitia. I actually want to call it supra. You have invoked a higher jurisdiction before they got to put you in a court hearing and steal your child through their racketeering. You said, hey, they stole my child unlawfully, help me. That's what you say, and illegally. Just bypass the whole state stuff and engage them. And if they're going, and then the racketeering will be exposed very quickly after that, one way or the other. Either the District Feldman and kicking these out, but guess what? Those are insurance policies. You just you take that receipt, you take that stamp, and that's an insurance policy. The worst case scenario is we will bankrupt these criminals.
I hope
will
so.
Bankrupt
listen, I have to wrap it up. I have to go.
Thank you for the forum. I just want everyone to understand in a variety of ways that the Rooker-Feldman Doctrine is being grossly applied here, and that's what we're going to tackle.
We will keep addressing this issue, and we'll continue to have you on the Porthole to Justice, because this is something that we really need the people to understand. Because this is a racketeering, huge, illegal.
And it's rampant, and it's rampant. It's horrible. It's gross criminality.
And what they're doing in California is basically legalizing this, the human trafficking in the courts.
Yeah, with private hearings with judges.
Yeah, private hearings with judges, and I want to have you on a show about that. Okay?
That is, I can't even. That blew my head off. My head popped off when I read that.
Yes, we will have you back, Lotus. Thank you so much. Everybody,
thank you.
This has been another episode of Off the Cuff, Porthole to Justice. Bye, guys. Oh, you can tune in on Spreaker.com, and you can subscribe to the show. It's really easy, and you can post questions on our chat. I'm on Twitter, Instagram, and Facebook. All right, bye, everyone.